All right, hello everyone. Welcome to week two. I hope you're going well at the start of semester. Remember to please reach out if you have any problems or questions at all. We also have Dr. Sophie Rigney as well, who is there to support you too during our international law journey. So today we're going to be, and I guess the rest of this week too, we're going to be looking at the law of treaties as well as how international law has influenced and shaped Australian law as well. So this is quite a large and can be a bit of a lengthy topic. And we have quite a bit to get through for this lecture. And again, having a problem progressing the slides. Oh, there we go. So this is what we're looking at for the lecture today. Firstly, the first half of it is about treaties. How do we identify them? How do we define them? How do we analyze treaties as well as interpret and apply them? Then we'll turn towards, well, how has international law impacted Australia? And look at the kind of dialectical interaction between international law and Australian domestic law. So this is the idea of what we'll be doing today. And then, of course, we'll go a little bit more into these topics during our tutorials during the week. And just very importantly for our in-person class on Tuesday, this is back to in-person classes. I know week one are online, but now we'll be seeing each other face-to-face on Tuesday. So please come along then. And I'll see our Thursday class at their usual time and format. So let us begin. So let's firstly talk about, well, what exactly is a treaty? And treaties have now become almost like the dominant vehicle for international law making. And we'd probably say it is like the primary source of the law applicable to state parties. The international community now, after decolonization and other processes, now number some 192 states. And so the tradition, the kind of certainly historical and traditional reliance upon customary law to respond to global problems has become very, unwieldy, and uncertain. And so the treaty, by contrast, provides more, clear statements of rights and obligations of state parties towards certain problems and can create effective international institutions with regulatory and adjudicatory powers. So as a written instrument, treaties are kind of analogous to almost to private contracts, national legislation maybe, and state constitutions, and can be a really valuable means of international regulations. And it's been common practice, for example, for the United Nations, often on the recommendation of the International Law Commission, to convene diplomatic conferences to negotiate multilateral treaties to deal with emerging international problems. And examples that maybe might come to mind are multilateral treaties dealing with climate change, slave trading, establishment of an international criminal court previously, protection of biodiversity, and laws regulating maritime zones. And many of these topics, we'll come back to during the course as well. But this resort to international treaty making, which are, agreements between, two states, for example, or several different states at the same time, can sometimes create their own problems. Treaties can, form webs of obligations between states and between, many states, whether they're in bilateral, multilateral, or even regional-based treaties. And these obligations can sometimes total like the thousands of separate agreements, which then raises a lot of intricate problems of, hierarchical relationships of international rules, which one comes out on top when there are contradictions, for example. And as treaties are increasingly more employed to respond to a wide range of global issues, there is this kind of ongoing risk of fragmentation of substantive international law as more and more treaties are developed. And the need to gain a consensus in multilateral negotiations can also lead to the adoption of language that is vague and obscure to mask profound disagreement among parties to a treaty. And you've probably seen that in a lot of the climate change multilateral discussions where a lot of the language is very vague and non-committal. And in this kind of context of ongoing fragmentation, ambiguity, and rapid growth of international law, Now, the principles of treaty interpretation play a really vital role to ensure the future coherence of international law as a broader whole. Now, the Vienna Convention, which we'll talk about at some length here, employs the term treaty. There's not really much that I guess turns on, well, what does this term actually mean? And there's lots of different names that are used to actually define things that would really be understood probably as treaties. And so states have used names such as convention, charter, pact, covenant, concordiate, declaration, agreements, exchanges of notes, agreed minutes, exchange of letters, mandates, memorandums of understanding, joint communique, protocols, and even, very confusingly for any domestic lawyers, final acts and statutes, all to refer to treaties. So the term and definition of treaty can sometimes be, I guess, a little bit hidden behind all these different nomenclatures for these documents and agreements between states. Now, as we'll see a little bit later in the lecture too, there's a preeminent importance given to interpretation in the judicial process and in looking at treaties, and especially the rules set out in the Vienna Convention on the Law of Treaties, or just the Vienna Convention, as I will address more soon. And the reason for this importance of interpretation in the judicial process around treaties is the inherent defects of language, which is often found in treaties. Obviously, no human language is perfect, and a lot of the issues around treaty interpretation and application is, well, how can we understand what certain words mean? And this is the role interpretation fulfills. It's not a perfect tool, and we'll talk about it in more detail, and it functions on an ad hoc basis, but it is the best kind of tool and way that we have to approach understanding what language means, finding out what these mixture of symbols might what kind of consequences they might have, and the disambiguation of terms used in everyday language, and especially in international law, language is an ambiguous element which is in a larger system of complex international law, and it has a lot of complications. There's a lot of interconnected obligations and rights, as I mentioned before. There's overlaps of customary law, for example, and so there's a lot of interlap with and within international law, which makes the application of language even more difficult. And especially now we're getting, even, well, maybe not so much more recently, but certainly in the early 2000s, there's a increased growth of international courts and tribunals, which then can kind of lead to different varieties of approaches to different treaty interpretations. So this issue of interpretation is a difficult one, which will come back later on. So let's talk more a little bit about the Vienna Convention and treaty making itself. So the Vienna Convention itself is very important for us to understand. There's a number of articles that are worth being aware of, and I've named them here on the slides. But the Vienna Convention doesn't really prescribe any form or procedure for treaty making. The convention applies only between states and provides in Article 6 that every state possesses capacity to conclude treaties. So the states have this capacity to make treaties in international law as per the Vienna Convention. The representatives of states must have full powers to conclude a treaty on its behalf, or must be considered as having such power as virtue of their representation. And as the International Law Commission points out, instances in which a treaty is concluded without authorization are quite rare, because the representatives may not have the authority to conclude treaties, and these are quite rare instances that don't really come up very much. But the Vienna Convention does address issues of representation and authority in Articles 7 and 8 if that issue ever comes up. But maybe more substantively for us, the first major kind of area in the Vienna Convention which is relevant for our understanding is that meaning the consent to be bound. So the convention sets out each of the steps necessary to create legal obligations for parties to a treaty. Now, once the treaty has been drafted, the text must be adopted by two-thirds majority, which reflects customary practice. There is a contemporary preference for achieving agreement by consensus, by which those states that have kind of differing positions will place their concerns on record, but will otherwise allow the text to proceed. And then once adopted, the text will be authenticated as a final act, which incorporates the text. Now, the consent of a state to be bound by a treaty is a really critical requirement in the creation of obligation, and it can be evidenced by things such as the signature of the representatives, exchange of instruments, some kind of ratification domestically, acceptance or approval or accession in whichever what way that may be. Now, over the last 30 years, states have usually required subsequent ratifications of multilateral treaties agreed at diplomatic conferences domestically to ensure the treaty making power of the executive is submitted to the scrutiny of parliamentary control. And we'll talk a little bit about what that means, for instance, in Australia a little bit later on. Now, this modern reference back to the constitutional requirements for ratification is now a norm before most formal treaties will bind states. Although the executive treaty making power is a question for domestic laws and practices do differ widely and widely rather than wildly on this point. And in the UK, for example, treaty making is the prerogative of the Crown. In the US, the executive has treaty making power, though they kind of have to have some advice and consent of the Senate. And in Australia, which again we'll talk about in much more detail soon, the power to enter into treaties is an executive power under Section 61 of the Constitution of Australia, but relying on the external powers. Yeah, we'll touch on that quite shortly. But the Vienna Convention addresses this issue of the consent to be bound in Articles 11 to 16. Now, in terms of when does a party or when does the treaty enter into force, this is kind of a bit of a vexed issue because the process for ratification of a treaty can be really lengthy. The Vienna Convention provides for the period during the twilight zone, as it's called, between signature of the final act and ratification, and then entry into the force of the treaty. And under Article 18, a state must refrain at these stages from acts that will defeat the object and the purpose of the treaty. Now, I mean, this is kind of an interesting point. Besides, this provision of entry into force, Article 18, had really a little scholarly attention until reasonably recently, because in an unprecedented act, the United States notified the UN Secretary General a number of years ago of its intention not to proceed to ratify the Rome Statute of the International Criminal Court, which you'll learn was the kind of originating statute and treaty for the establishment of the ICC. And at that time, the United States maintained that it had no legal obligation arising from its signature in late 2000 on that Rome statute, because the US signed it, but then they was like, no, we're not actually going to go ahead with it. And within the document itself, it did seem to allow such a notification, but even before the US, notified that it wasn't actually going to ratify the Rome Statute of the ICC, it had already started negotiating what were called Article 98 agreements to basically ensure its nationals would not be extradited for trial by the ICC. And so there's numerous American domestic legislation which blocks the United States participation in UN peacekeeping forces, for example, unless there's guarantees that the United States service members will be protected from prosecution by the ICC. And the United States has actually concluded many bilateral agreements with states where other states have pledged not to transfer members of the United States forces to the ICC. And I think those agreements are now over 100 now. And so this, even though the United States signed the Rome Statute, they then prevented their entry into force of this document, and then have concluded many other treaties to prevent the actual effect of this document on their forces, which there wasn't a lot of interest in this article until this occurred in the early 2000s. Now, application is probably one of the more important points of treaty making under the Vienna Convention we have to worry about. Because there's a few general rules of application, and the first one is that treaties are generally binding on parties and must be performed in good faith. And this is in Article 26 of the Vienna Convention, but it's also kind of more broadly customary law. And if any of you have studied contract law as well, performing contracts in good faith is also something that can be an implied term at law. For example, so very similar in international law, the same situation relatively applies. So every treaty in force is binding upon the parties to it and must be performed by them in good faith. And international tribunals continue to place quite heavy emphasis on this. Now, Article 29 of the Vienna Convention reflects the rule that treaties are generally binding on a party in respect of its entire territory, including colonial or other external territories. And so, these treaties will be applicable to also occupied territories as well. So, as well as, the maritime zones of a coastal state where relevant too, and we'll kind of look at this in tutorials as well. And for example, as in Australia, there's legislation that excises territory for the purpose of the application of migration laws to asylum seekers, which has been really important in relation to the convention relating to the status of refugees, which is something we'll come back to a little bit more later. Now, since the Second World War, there's importantly in this kind of broader topic, there's been hundreds of international organizations that have been created with various international legal personality, which also then have a capacity to sue and be sued, and their kind of effect and position at international law is also a really important one. And it's been a vexed one where there's been a lot of questions. Well, can international organizations enter into treaties? Do they have the power to take action against other states, for example? And so there are still remaining questions about, what kind of rights and obligations, international organizations can have. So we'll turn our mind back to international organizations at a later date, but I just wanted to mention them here, that they can have also relevance to treaty making as well as the application of those treaties. Now, in terms of reservations to treaties, a state, may have taken an active part in drafting a treaty, for example, and maybe fully supported its central objective. But for reasons of maybe domestic law and policy or politics, they may want to modify in respect of itself, the legal obligations imposed by the final agreement. And Article 2 of the Vienna Convention defines what's called a reservation. So states are allowed to make reservations under Article 19 of the Vienna Convention, unless it's prohibited by the treaty itself or is incompatible with the object and purpose of the treaty. An advantage of permitting reservations and kind of why these exist is that it kind of enables states to join a treaty where, in the absence of some qualification of their obligations, they could not or would not want to become a party. But less constructively, states have taken the opportunity to make reservations to treaties on becoming a party, which still, despite the kind of prohibition here, they do adopt reservations that are contrary to the treaties themselves. So you do see that quite frequently, unfortunately. Now, in addition to the question of whether state parties, accept a reservation or enter into one, is the substantive question of the legal effect of a reservation that is then found to be impermissible. Like, for example, is it possible for a state to make a reservation to a human rights provision which is non-derogable. There's a case which we don't need to know a huge amount of detail on, but called the restrictions on the death penalty case. Guatemala made a reservation to Article 4 of the American Convention on Human Rights of 1969, which guaranteed the non-derogable right to life. These are rights that are absolute and may not be subject to any derogation. Guatemala rejected this right in respect of common crimes relating to political acts. And the American Court of Human Rights determined that the test of validity here as to whether this reservation was compatible with the object and purpose of the convention. And in the view of that particular court, Guatemala's reservation did not deprive the right of life of its whole purpose, and so it was acceptable in that case. And similarly, the International Court of Justice considered the validity of Rwanda's reservations to the Genocide Convention in the armed activities on the territory of the Congo case. And this reservation stated on behalf of Rwanda that Rwanda did not consider itself bound by Article 9 of the Convention, which provides that disputes relating to the convention shall be submitted to the ICJ at the request of any party to this dispute. And the International Court of Justice held that while the convention enshrines rights and obligations to all parties, and the prohibition on genocide is jus cogens, as we mentioned before in our previous lecture, the reservation was not incompatible with the object and purpose of convention again, as it bared on the jurisdiction of the court rather than substantive obligations relating to acts of genocide themselves under the convention. So, really, even though there is a restriction on parties making reservations which go negatively towards the purpose and objects of the treaty, there are, like I mentioned, some quite prominent cases where international courts and tribunals have allowed this. So, in terms of interpretive declarations, this is kind of a tool where states have attempted to avoid any challenge by other parties as to whether a reservation is valid as consistent with the object and purpose of the treaty, as we were just discussing, or otherwise are unacceptable, by adding this interpretive declaration to the terms of their consent to a treaty. There can be kind of distinctions between declarations that do not exclude or modify the terms of the treaties and those that do. The legal effect of an interpretive declaration depends really upon whether the declarant seeks only to offer an interpretation of the treaty that may be found, subsequently incorrect, or whether the declarant purports to make its acceptance of the provision in question conditional upon acquiescence in that interpretation. The significance of making a interpretive declaration that is then found to be incorrect is that it may have, in subsequent proceedings to interpret a treaty, it may have significance there, and it'll vary according to whether the declaration has been accepted, ignored, or objected to by other contracting parties. Where a declarant kind of purports to make an acceptance of a provision in a treaty, for example, conditional upon acquiescence to its interpretation, this type of interpretive declaration must be assimilated to a reservation. Because it's kind of like asserting that its interpretation overrides any contrary interpretation that the declarant has purported to exclude or modify for the terms of the treaty itself. Now, this is our kind of last point of treaties before we jump into the Australian domestic law and the interaction between it and international law. And we're going to touch on the important point of the interpretation of treaties. And I mentioned at the start, this is kind of where all of the meaty part of our exploration of treaties kind of centers on. And like I mentioned before, there is a huge increase in treaties across the world, especially multilateral treaties. And so this process of interpretation has had a growing significance in international law. And jurists and academics have observed that international tribunals adopt various approaches to treaty interpretation. And they take a number of different approaches. They might emphasize the natural and ordinary meaning of text to understand it, which is a textual or objective approach. Or they look at the intentions of the parties, which is like a subjective approach to understand treaties, or or the object and purpose of the treaty itself, which is like a teleological approach. Um, and sometimes scholars and other interpreters of treaties have rather looked at principles like effectiveness. How can we interpret treaties to make sure they're effective, or even use various Latin maxims as well, which kind of reflect what you may have seen in public law, but we won't go into too much detail here. But in some of these approaches, when, for example, we're trying to find, well, what are the intentions of the parties and kind of the subjective approach, it can be impossible really to ascertain the real intentions of a party. And so it can be really difficult to know, which state behavior is legally relevant to find out, well, what are the intentions of the parties? And therefore, how can we interpret this particular treaty? And so it's also been said that neither, one particular type of analysis, whether it's objective, subjective, teleological, whatever it might be, can alone provide a satisfactory answer to treaty interpretation. And there must be a fusion of multiple techniques to reflect the consent of states around a document such as a treaty. And Article 31, which I have on the slides there, is actually a attempt to facilitate this fusion between various interpretive methods of the Vienna Convention. And it combines established practices of international tribunals in like a single combined operation as it has been described. And as you can see on the screen here, on the Article 31, subsection 1, a treaty must be interpreted in good faith, according to the ordinary meaning of the terms in their context and in light of its object and purpose. Then also courts may take into account any subsequent agreements or practices of the parties that may be relevant as well. And I won't go through every part of this, but this is what we should work through when trying to, interpret treaties themselves. And I'll let you have a read of these four subsections in your own time. But the courts have generally worked through these dot points in the interpretation of treaties, these have been frequently applied by the ICJ and other international tribunals in respect of breaches, for example, of treaties, as well as changes of circumstances of treaties, as well as termination of treaties. So in one particular example, the ICJ in Kili/Sadudu Island found that the Vienna Convention rules on interpretation reflected custom. And there is no instance in which an international tribunal has denied the customary law status of any provision of the Vienna Convention, and recently established tribunals, such as appellate bodies of the World Trade Organization, for example, also refer to it when interpreting their constituting instruments. So this Vienna Convention, especially Article 31, in terms of interpreting treaties, is not only written law, but also it's broadly customary law as well, which has a much broader acceptance, and it reflects that it has not really attracted a whole lot of legal controversy. There's still some uncertainties, and especially in relation to the concept of jus cogens, the validity of reservations to human rights treaties, and the effect of purported withdrawals without notice as well. But generally, this is broad, good law that has been applied really widely to interpret treaties, as well as other documents of governing bodies, for example. Now, there are some general rules as well that the Vienna Convention on the Law of Treaties helps us find. And these are meant to kind of lead us to the correct legal meaning of a treaty provision to be interpreted. And there's really hardly any kind of legal argument about treaty interpretation, whether it's in a scholarly article, a judgment that does not take the Vienna Convention as its benchmark. The kind of focus on Article 31 constitutes a state of play, like the kind of foundations of where we start. And it has been said that international lawyers have become obsessed with the rules of the Vienna Convention. And this is also quite interesting because prior to the Vienna Convention, when it was constituted, this idea of interpretation was characterized as an art rather than a prescriptive science as we see now. And just like I mentioned before, there was lots of different ways of interpreting treaties, whether subjective, subjective, theological, and so on and so forth. But now it's more scientific, and international lawyers and courts may be called obsessive about applying them. So there is kind of conventional wisdom that Article 31 and even other rules of treaty interpretation will get us to the correct meaning of treaty provisions if competently applied. And so the interpretive methods proposed here are meant to kind of rationally justify certain outcomes, to kind of give the idea that if judges or international lawyers go through them, then they are doing a professionally competent job. But this law and practice of treaty interpretation has actually shifted regularly across time. There hasn't been a coherent pattern leading to the Vienna Convention as we've seen here. And even Grotius, devoted an entire chapter of his work on the law of war and peace to the interpretation of treaties. He spelled out a number of different ways of interpreting and noted it was a really vexed issue which had drawn from, Roman law, grammarians, logicians, rhetoricians, and many other people to try to understand interpretation of treaties itself. The finally inclusion of binding laws of treaties, which happened after World War II, and it was led by the International Law Convention. This was widely regarded as some kind of victory, that there was this prescriptive points of interpretation that could be followed. It was an accomplishment of the development of international law. There were some rules for international lawyers to follow as well. And it also helped, represent a step forward on treaty interpretation. And it was hoped as well, the respect of treaties by international states and other parties too. So the important point here too is that the one of the outcomes of codifying, well, how do we interpret treaties, is that there's a logical preeminence of the text on general rule of interpretation in Article 31. And it was justified that the text must be presumed to be the authentic expression of the intentions of the parties. So, these are kind of some kind of like background musings on the background of the Vienna Convention, how diverse interpretation was, and now how it's codified and how popularly it was used today. And there is still a lot of contestation about, how, strictly lawyers should look at the words of treaties and use them. But broadly overall, Article 31 is supposed to bring in lots of different interpretive approaches. And when we're trying to interpret what treaties may mean, it's always good to start with Article 31 and move through these four subsections. And like I mentioned, interpretation is kind of where the bulk of treaty law is focused on. And so we will, be coming back to this as well over the course of the remaining weeks. So this is more or less what we want to touch on in terms of treaty law. We're now going to take a little bit of a different track, although not totally unrelated, and then have a look at, well, how does international law interact with Australian law, which also includes a lot of, thinking about, well, what about treaties that Australia has entered into? And this relationship between international law and domestic law, and certainly in Australia, has become more complex more recently. And there's been several factors which have contributed to this. Firstly, we live in a so-called globalized, interconnected world in which it's quite hard sometimes to delineate between domestic and international affairs. And this is evidenced by the development of the internet and other digital technologies. Another second factor is this shrinking of what was called a reserved domain of issues previously regarded as exclusively within the competence of nation states. And so international law is kind of like increasingly reaching into what would previously have been called the domestic arena. And this is especially true in like international human rights law, international environment law as well. The third point is that following the 20th century, where there was a lot of rapid normative development, we now are in a period where international law has a greater focus on implementation, compliance, and enforcement. And so the role of domestic law is increasingly important in that. And a fourth, maybe related factor is also the increased awareness and understanding of international law generally, and its use as a tool of domestic advocacy and policy making in Australia. This, discourse of international law, international rights is something that you hear a lot more frequently now. Even not just by lawyers but also by politicians in the media and just regular everyday people as well. Now, there obviously, many of us have probably already done a public law course in our studies, for example, or any other courses that purport to look at Australian law. And there is, of course, important differences between international law and domestic law, not only in their mode of, how they're created, but also like their subjects, the sources of legitimacy, and enforcement mechanisms as well. Now, there's two main theories that try to explain the relationship between international law and domestic law. They're monism and dualism. And they're linked closely to the concepts of transformation and incorporation. The monist view, which is derived from natural law theories, is that international law and national law form part of the same kind of universal normative order. And so international law does not need to be translated into national law. Instead, the act of ratifying international law immediately incorporates it into national law. Whereas the dualist view, which is informed by legal positivism, is that international law and national law are two separate legal orders, and that for international law to apply domestically, it must be first like transformed into domestic law. And there's two key principles underlying this approach: is that state consent is the basis for international law, and also the separation of powers. And this is the concern to protect the supremacy of the legislature, so that the executive can't just go willy-nilly join in whatever international laws it might like. There has to be some kind of ratification, for example, by the Parliament. Now, like I mentioned, this idea of monism and dualism relate also respectively to incorporation and transformation approaches. In the incorporation approach of international law is automatically incorporated as part of national law, to the extent that it doesn't, conflict with domestic statutes or judicial precedents. While the transformation approach requires that international law first be transformed or translated into domestic law by an act of the state, such as by enacting some kind of domestic legislation. These are, monism and dualism, we might describe them as theoretical approaches to understanding this relationship between international and domestic law as domains of law, while incorporation and transformation relate more to the manner by which international law actually becomes part of domestic law. In Australia, the dualist and transformative approaches which are inherited from the United Kingdom, are predominant in relation to treaty obligations. Treaties do not form part of Australian law unless those provisions have been validly incorporated into domestic law by statute. Um, but sometimes just stating Australia is a dualist country is probably an oversimplification, as we'll see in the discussions of customary law and how it relates to Australian law. So we wouldn't just say Australia is a dualist country necessarily, and we'll speak a little bit later as to why. Now, apart from the direct effect that treaties may have on domestic law through legislative implementation, which we'll touch on very soon, international law also has important indirect impacts on Australian domestic law. And there's maybe four major types of indirect effects, which include which include the influencing of the development of the common law, and your text touches on this quite on this briefly. It informs presumptions of statutory interpretation. There's some divergent thought about how it helps interpret the Constitution, and also has affected exercise of administrative power and executive discretion. There's also, as a kind of like separate issue on its own, an uncertain influence of customary international law on Australian domestic law. And we'll touch on not only the direct impacts, especially from treaties, but we'll also talk on some of those indirect aspects, which your textbook also fills in there, and touch on customary law as well. But just like I mentioned at the start of week one, and just like I was doing for the discussion on treaties, I'm kind of just trying to supplement what your textbook is already saying, trying to keep relatively to very similar headings of the discussion so you can follow along. But I'm hoping to kind of, plug some gaps for your textbook, provide a little bit broader information, and also look at things a little bit differently. I don't look at exactly all the exact same things that the textbook does, but my provision here is just to provide some emphasis and plug some holes where needed, which is not always the case. Now let's look at treaties and Australian law. So this is how international law kind of directly affects domestic law. Now, the Commonwealth's executive power, and again, a lot of this might be, revision from public law classes, for example, but the Commonwealth executive's power to enter into treaties is a plenary one, which permits Australia to ratify or accede to treaties on any subject matter. There is no requirement of parliamentary approval before the executive can enter into a treaty arrangement. And historically, only in a few cases has the Commonwealth Parliament passed legislation explicitly approving Australia's ratification prior to action being taken. One example is where legislation was introduced approving Australia's ratification was of the Convention on the Prevention and Punishment of the Crime of Genocide. And provisions, as I mentioned before, provisions of a treaty to which Australia has become a party do not form a part of Australian law unless and until there has been a legislative act to incorporate them into Australian law. There is a narrow exception for some treaties, such as treaties of peace, which are regarded as self-executing. So they have a legal effect without any domestic act of incorporation. The general rule requiring an act of domestic implementation is quite firmly established. In the reasonably famous case of Immigration and Ethnic Affairs versus TEOH, which your textbook speaks about at some length. Chief Justice Mason and Justice Dean explained the genesis of this rule in terms of the separation of powers between the executive and the parliament. I won't quote that judgment, but it's mentioned a little bit in your textbook. But this is where a lot of this idea has been quite clearly enunciated. So most treaties broadly, explicitly or even implicitly leave to the discretion of the state the means for implementing their treaty obligations. The particular domestic instruments that the state might employ to perform its international obligations are really almost a matter of indifference to international law. But there are some treaties that might be more specific about what needs to happen. And there are examples, for instance, where Australia there has treaties it's entered into where there's specifications as to what legislative action should be taken. So, for example, under the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, state parties are obliged to legislate so as to criminalise torture. This is a lot more specific. And in Australia, the publicly stated policy of the government is to ensure that necessary legislation is enacted either by the Commonwealth or by state and territory governments before ratification of a treaty more broadly. And an illustration of this policy is the legislation passed by federal parliament on the topic of cluster munitions so that Australia could ratify the Convention on Cluster Munitions. Now, with the exception of treaties that involve the appropriation of funds or that otherwise require legislation to give effect to their provisions, the Australian Parliament has historically played no formal constitutional role in the treaty making process. However, beginning in the 1980s, there were many parliamentarians and also the wider community began expressing concerns that Parliament wasn't involved enough in the treaty making process, and this criticism steadily grew, and especially among and within the Australian states. And in the mid 1990s, the Senate Legal and Constitutional References Committee conducted hearings into the treaty making process, which ventilated criticisms of that process. And then later that year, the Senate committee recommended that legislation should be enacted to establish a parliamentary committee, which would, among other things, report on proposals by Australia to join a treaty. These recommendations sought to address what many considered and what your textbook notes as a democratic deficit in the way the executive branch exercised its exclusive responsibility for treaty making. And the aim of the treaty process at this time, the stated aim of it was to restore confidence in the process by eliminating this democratic deficit inherent in it. More specifically, the resultant policy from this provided that the arrangements for parliamentary scrutiny of treaties through tabling them in Parliament would apply to all treaty actions, multilateral as well as bilateral, and extend not only to new treaties but to all actions to amend, terminate, or withdraw from treaties. Now, the effect of this policy, which has been generally reaffirmed by successive incoming Australian governments, is that parliamentarians make considered reports on proposed treaties before the government decides whether Australia should join them. Now, important to note, the government or the executive doesn't actually have to follow these reports. It can take treaty action even where the committee recommends against it. And so parliamentary approval is not formally required before the executive branch of the government agrees to take treaty action. And so the prerogative power of the executive under Section 61 of the Constitution, which we'll touch on in a moment, has been constrained through the adoption of this reform process in the mid 1990s, but it actually hasn't been formally limited in its real scope. And I mean, kind of on that point as well, and again, many of you will know this from public law. The executive government exercises prerogative powers of the Crown under the Section 61 of the Constitution, which includes the power to negotiate and enter into treaties. And then once the treaties are entered into, whether or not the government worries about any particular report from a parliamentary committee, then Parliament can make laws with respect to external affairs, which is a power under Section 51, subsection 29, which covers the implementation of both treaties and customary international law. So entering into treaties by the executive government is Section 61, and then Parliament actually making laws with respect to these treaties under Section 51, subsection 29. Now, another way that international law can affect domestic law more indirectly is in relation to the exercise of administrative power. And in quite a controversial development, the High Court in the Teo case, which I'll touch on in just a moment, it accepted that if a decision maker was proposing to make a decision contrary to international law, so an administrative decision, the applicant would have the right to be heard in relation to the matter. And this was enunciated in the Teo case. And again, this case is mentioned in your textbook, but Mr. Teo, he was a Malaysian citizen who had been sentenced to a period of imprisonment in Western Australia for drug trafficking. He had several young Australian children who were not able to be cared for by their mother, who was an Australian citizen. And an order was made under the Migration Act to deport him for not fulfilling the requirements of a good character. Now, in this case, there's a few issues, but one of the issues relevant right now was that it was the relevance, I guess, of the UN Convention on the Rights of the Child, because that treaty required that where decisions are made, administrative decisions by a government are made that affect children, the interest of the children must be a primary consideration. And the decision maker in deciding to deport Teo had not made the best interest of the children a primary consideration. And so a majority of the High Court found that entry into a treaty by the Australian government generated a legitimate expectation that administrative officials will act in conformity with treaty obligations accepted by Australia. Even when they haven't been incorporated into domestic law, unless there was any kind of like contrary legislative or executive indications. This was quite a controversial decision, and there has been many attempts by the executive to reverse that since. Now, one of the, now thinking about how international law impacts statutory interpretation, another kind of indirect impact of international law, there's an accepted canon of statutory construction. Again, you may have learned about this in your public law class, that it's the presumption that Parliament intends to give effect to Australia's obligations under international law, including treaties. And again, in the case of Teo, the High Court viewed this presumption as operating in instances where the statute or subordinate legislation is ambiguous. And in its view, the court said that if the language of legislation is susceptible of a construction which is consistent with the terms of the international instrument and the obligations which it imposes on Australia, then that construction should prevail. And in addition to this, common law rule of statutory interpretation, also the Acts Interpretation Act 1901, the Commonwealth legislation, also contains specific reference to the use of international law as extrinsic material. And Section 15AB, subsection 1 and subsection 2 of that Act authorizes the use of any treaty or other international agreement that is referred to in the Act in order to clarify a provision of the Act that is ambiguous or obscure, or that on its face or prima facie is manifestly absurd or is unreasonable. So the treaty may also be used to confirm the ordinary meaning of the Act in the light of its context and its object and purpose. An example of the High Court's usage of international law, where in circumstances where the treaty is referred to in the legislation, is its decision in Plaintiff M70. And this is where the court referred to the fact that the Migration Act, our domestic law, was intended to implement the Refugee Convention and its protocol in giving meaning to particular sections of the Act. So they could refer to the Refugee Convention to give meaning and interpret especially ambiguous parts of the Migration Act. So now we've now touched on, the direct impacts of international law through treaties on Australian law. We've touched on some aspects of the indirect impacts. We are now going to finish off by just touching on customary international law and Australian law, which is a relationship which we might say is still quite unsettled. And a lot of the difficulty in the interaction between customary law and Australian law, or customary international law and Australian law, is that there's inherently more complex nature of customary international law. And this is just the general difficulty of identifying the rules of customary law. And proving, as we mentioned last week, well, what's the required state practice for customary law to emerge and opinio juris. Um, there's still some uncertainty that remains, but the basic position in Australia is that the courts seem to have rejected any automatic incorporation of customary international law into domestic law, um, but customary international law may still have a significant influence, and particularly in relation to the development of Australian common law. And the major case that discusses whether customary law customary international law, can be a source of domestic law in Australia is Chow Hong Ching versus the King, which was also a case mentioned in your text. Now, this case concerned two Chinese nationals who had been convicted of criminal offences against a local resident on Manus Island, which was at that time part of the Australian Trust Territory of New Guinea. So we had a direct colonial relationship over that territory. And the issue for the High Court was whether the individuals enjoyed sovereign immunities under customary international law, which affords immunity to members of visiting armed forces. So the judgment here is regarded by the High Court as the foundation of the Australian approach to customary international law. And the judge here, Judge Dixon, observed that the idea that international law is automatically incorporated in national law is without foundation. So that's also important in separating, the monist from the dualist approach too. He proposed, however, that while not a part of domestic law, international law is one of the sources of national law. And Chief Justice Latham, in that case as well, stated that international law is not, as such, part of the law of Australia, but a universal part of. Sorry, one second. Hello, everyone. Sorry, I just had my cat jump up at my computer, so I just had to pause the recording. But as I was mentioning, in Chow Hung Ching versus the King, one of the important judgments here was not only Justice Dixon, which I just mentioned, and who observed that this incorporation or the automatic incorporation of international law into domestic law is without foundation, but also Chief Justice Latham stated that international law is not as such part of the law of Australia, but a universally recognised principle of international law would be applied by our courts, which was still a quite ambiguous statement. Because, the difficulty that subsequent interpretations of this case by courts and academics as well, the issue is with interpreting the court's references to international law. When the Chief Justice here is saying a universally recognized principle of international law would be applied, is this international law referring to treaty law, custom, or both? And 3 of the 5 judges in this case found that Australian common law could contain customary international law rules. The question was whether this occurred automatically through some kind of, an incorporation approach, which 2 of the judges seemed to held, or believed or ruled on, or only when a judicial act created a new domestic rule that relied on customary international law as a source, as one of the judges appeared to find. So this case kind of didn't help really fully clarify exactly well how how is customary international law integrated into Australian domestic law, but it is a foundational case, an important one to note. Again, just illustrates the ongoing unsettled relationship between these two areas. So this is more or less what I wanted to get through for the lecture today. And sorry, I think I probably went through parts of it very quickly because I thought I was going to run out of time, but I think it actually turned out to be okay. Um, Now we have tutorials as well coming up in week 2. And for the Tuesday class, please keep in mind we are back in person. Please make sure you engage with the required readings and especially the textbook readings too at this stage, because like I mentioned, they're a very important supplement to the class or the lecture itself. And we are also going to touch on the first assignment in some more detail in week 2 as well. I gave you a little bit of an introduction to the broader assignment regime in week 1, but in week 2 we'll go in a little bit more detail about that first assessment, which is now quickly coming up. So hopefully it'll ensure that you feel well prepared as it gets a little bit closer to the due date. That's my email there as well if you want to get in touch. But otherwise, thank you very much for tuning in, team, and I look forward to seeing you in class.